Due Process, recipient of 2 Mid-Atlantic Emmy Awards for Outstanding Talk Show Series and Outstanding Public Affairs Series.
Was the question back when he was first arrested. But whether or not this man is the Unabomber is no longer the only issue. Is he competent? Should he be facing death? Is the system equipped to cope with Ted Kaczynski? Those questions and more on the docket for this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the Legislative Manual.
The government says he's the Unabomber, the anti-tech terrorist who for 18 years killed and maimed and evaded a national manhunt. Ted Kaczynski, for the record at least, says he's not guilty of 3 bombing murders, including one right here in New Jersey. But the questions being raised by his prosecution so far have had surprisingly little to do with his guilt or innocence. In fact, the stalled Unabomber trial is just one of the terrorist cases that made headlines in recent weeks. The verdict in the Oklahoma City bombing trial, the sentence for the World Trade bombing mastermind. They've raised essential questions about how we prosecute and how we punish. But none so much as the trial that's yet to begin in Sacramento. We'll look for answers from some expert guests, but first with some perspective on the bizarre events of the last 2 weeks in the complex prosecution of Ted Kaczynski. Here's Sandy King.
Well, Raymond, the first thing perhaps we should explain is why we've put the show we promoted for this week on hold until next week. Those questions you talked about were just too compelling and too timely. Ted Kaczynski is due back in court this week for a hearing on whether he is competent to stand trial or even represent himself in proceedings that could ultimately cost him his life. A psychiatrist's findings may determine what's next. The mental defect defense, the right to representation pro se, plea bargains in high-stake cases, and the death penalty. The Unabomber case has them all.
Are you responsible for these bombings? Sir, are you responsible for these bombings?
And if this genius mathematician turned technophobe hermit is indeed the man they call the Unabomber, it took 18 years to catch up with him. 18 years of killing and maiming by mail bomb.
The bomber has specifically targeted these individuals. I mean, it's not a random type of situation.
But the targets were sufficiently unpredictable that until his brother dropped a dime, Kaczynski wasn't even close to being caught.
Kaczynski was so far out of the loop that in some ways he really evaded those normal means of detection.
Do you think they'd have gotten him without his brother's assistance?
I think it would have been very hard. I mean, it's like finding a needle in a haystack.
Kaczynski's brother had turned him in the hopes not only of stopping the carnage, but of saving his brother's life as well. And that's just one of the things that makes the government's insistence on seeking the death penalty so controversial.
I think it would be a very hard-hearted person who didn't at least listen to what the brother had to say and consider that as part of the mix. I don't think that should determine the outcome, but it's a voice that deserves to be heard.
Do you think it is being heard?
My sense is they probably listen to everything. Obviously, the victims' voices are probably the most important.
Victims like the widow and children of murdered North Caldwell ad exec Thomas Moser.
My dad's favorite thing to do on Christmas Eve was to gather his family around our piano and sing Christmas carols.
And though Kaczynski was arraigned in Newark in the Moser murder by closed-circuit TV, the Moser charges are not included in the 10-count indictment now set for trial. But his wife and a daughter were among those in the Sacramento courtroom where trial had been set to start 2 weeks ago, before Kaczynski's complaints about his representation put proceedings on hold.
About 20 years ago, maybe more, in a case called Ferretta v. California, the court found a constitutional right, I think under the Sixth Amendment, to represent yourself. And it is not an absolute right, but it's a very powerful right.
And it is that right that Kaczynski demanded when his court-appointed lawyers insisted against his wishes on an argument of mental defect.
Although his ideas are a little bit off base, I mean, he does have a construct of reality that's pretty similar to everybody else's. He understands what the real world is. The people he sent bombs to were, in fact, the people that he thought them to be.
He knows he's in a courtroom and not in a bathroom.
Correct. And I think probably he'll be able to conduct himself in a way, whether he represents himself or not, that will show kind of basic reality grip. So I think he's going to have a hard time with an insanity defense. Diminished mental capacity, there was a much looser and more fluid concept, and that's something that he may be able to get the benefit of.
But that's just the kind of benefit Kaczynski reportedly doesn't want.
There is a type of defendant that has a very strong commitment to either an ideological or a personal cause, and they're concerned that the lawyer's not going to let them have their day in court the way they want to have it. And that's
Which seems to be how it's been going in Kaczynski.
Correct, correct. I mean, and this is someone with an agenda and a mission which is, at least to this particular person, more important than trying to save their own life.
And that's left Judge Garland Burrell with some tough calls to make, calls that could be determined in part if the mental competency report clears Kaczynski, and if the accused bomber is therefore allowed to go pro se.
It really is going to be a debacle, whether he's going to try to use it as a platform for spouting off his beliefs, whether he's just going to sit there and allow himself to be convicted without fighting back. I mean, anybody's guess. And I think in some ways it threatens to make a mockery out of the trial.
That is, if there is a trial. Kaczynski has reportedly offered to plead guilty in exchange for life in prison, the same sentence that 2 convicted terrorists drew in unrelated federal bombing cases just this month. Terry Nichols in the Oklahoma City trial because a Denver jury couldn't agree on death, and Ramzi Youssef in New York in the World Trade Center case because his judge could not by law impose a death sentence.
You know what's striking is that we have 3 instances of terrorism which do not involve highly skilled or highly organized groups of the kind you typically think of. I mean, I guess the Ramzi Youssef group in the World Trade Center group comes the closest, but even they don't strike fear in the way that, for example, Carlos the Jackal used to strike fear.
But the former U.S. attorney for this state thinks, despite the government's resistance, that the Kaczynski case will never come to trial, that in the end there will be a plea bargain signed off on in Washington.
My hunch is there probably will be, and I say it because there'll be a lot of pressure given what's gone on in the case already, and particularly depending on how the competency hearing comes out, and if it looks like Kaczynski may really want to represent himself. They're going to be concerned about trying the case, having difficulty getting the death penalty because the defendant's behavior is kind of a walking advertisement for someone with a mental defect, and then having to fight the issue on appeal. So I think that that's going to put a lot of pressure on them for a life sentence, particularly if they think that they're not going to be able to get a death penalty in front of a jury.
But it still is anybody's guess how the chaos in that California courtroom will in the end sort out. Most experts, including Mike Chertoff, think Kaczynski will be found competent to stand trial. And if there is no plea bargain, that trial could begin almost immediately. As to what the trial will look like, Raymond, what is your guess? Will we see Ted Kaczynski representing himself?
I think almost without regard to how the judge rules formally, Mr. Kaczynski is going to be a very active participant in his own defense, perhaps even in a way that his own lawyers aren't happy with.
His own lawyers have said that they cannot morally, ethically represent him without bringing in the case of mental defect. That question, he says, is not permissible from his point of view. He says he doesn't want to be considered a sickie. How will that go?
Well, again, it may very well be that he'll succeed in keeping that out as a formal issue, especially since he doesn't apparently want to be interviewed by a psychiatrist. But one way or another, I think the jury is going to get the flavor of the mental defects that affect Mr. Kaczynski.
And finally, who will be at that table with him? Will it be these lawyers whom he has tried to reject? Or will the judge at the last minute allow another lawyer in?
It's likely that the judge will want him to go with these lawyers because whatever lawyer is sitting at that table is going to experience tension with Mr. Kaczynski. An interesting case, and we'll be putting all these questions to our guests, an expert on how federal prosecutions really work, a defense attorney who's an expert on death penalty cases, and a law professor.
Behavior is kind of a walking advertisement for someone with a mental defect, and then having to fight the issue on appeal. So I think that that's going to put a lot of pressure on them for a life sentence, particularly if they think that they're not going to be able to get a death penalty in front of a jury.
But it still is anybody's guess how the chaos in that California courtroom will in the end sort out. Most experts, including Mike Chertoff, think Kaczynski will be found competent to stand trial. And if there is no plea bargain, that trial could begin almost immediately. As to what the trial will look like, Raymond, what's your guess? Will we see Ted Kaczynski represent himself?
No matter what the judge's formal ruling, Kaczynski's going to be more actively involved in this defense than most defendants are.
But there will be lawyers.
Yes, absolutely.
And will the judge allow them to argue mental defect? Kaczynski says he's, in his word, no sickie.
It's unlikely in light of Kaczynski's position, and especially since he won't let himself be examined by government psychiatrists, but one way or another, it's hard to believe the jury won't get the flavor of mental problems.
And a final call here, Raymond. Will the people sitting at the table with Kaczynski be his current lawyers, or does he have a chance of having them replaced as he's asked?
Seems unlikely the judge would replace him because the kind of tension that's being experienced now is going to be there with any lawyer who sits at that table with
And
Mr.
just
Kaczynski.
too late on the eve of trial.
It's too late, and in fact, you could change 4 times, and I suspect the same tension would come up with any lawyer representing Kaczynski. But we'll be putting all these questions to our guests, an expert on how federal prosecutions really work, a defense attorney who's an expert on death penalty cases, and a law professor who's nationally known for his expertise on the insanity defense. Peter Harvey, David Runke, and Michael Perlin when we come back, so stay with us.
If a person elects to defend themselves as a lawyer, they get to question other witnesses, examine other witnesses, and have a presence before the jury and make an impression on the jury without actually being exposed to cross-examination by the prosecutor. So there's an advantage in that sense. But if a person doesn't really know the rules of law and the procedural rules, they can make a lot of mistakes. And it's a very, very risky business to try to represent yourself in a very complicated case.
And the possibility of Prozac. Maybe Prozac is what I was thinking. And the possibility of pro se representation is just one potential cause of confusion and controversy in the university. It must be Perlin's presence.
You weren't like this on court TV.
And the possibility of pro se representation is just one potential cause of confusion and controversy in the Unabomber case, as my guests are well aware. As a former assistant U.S. attorney, Peter Harvey knows just how complex the government's position is in this one. New York Law School professor Michael Perlin.
Bust it.
While they're at it, can you take university out of Professor Perlin's intro line on the prompter?
Can we get a mic check, sir, please? I'm sorry, I don't remember your name. Just
Michael.
Mic check your
Right.
name and...
My name is Michael Perlin, and I'm going to see Bob Dylan tomorrow night in New York City.
Cool, sir. Yep.
Right.
My name is Bond.
And for that reason, will not be invited to see.
Those had my face on when you mentioned Peter.
That's why they were doing it.
That's very good.
They were unable to.
Hello. 5, 4, 3, here we go.
And the possibility of pro se representation is just one potential cause of confusion and controversy in the Unabomber case, as my guests are well aware. As a former assistant U.S. attorney, Peter Harvey knows just how complex the government's position is in this one. New York Law School professor Michael Perlin may be the source on the insanity defense, while defense lawyer David Runke, joining us from Newark, has tried more death cases than anyone I know. Peter, I'm going to start with you because you were recently, at least most recently, with the government as a prosecutor. This is a case that some people thought was a cinch for the government starting out, and all of a sudden, all this chaos. Does it surprise you, and is there going to be a plea bargain to resolve it?
It does surprise me that Mr. Kaczynski has thrown the case into utter chaos, but it may be consistent with who he is as a person. I don't think there'll be a plea bargain here. I don't think the government wants a plea bargain. The public is calling for death. We want to see revenge. We want to see this man put to death. And I'm speaking generally about members of the public.
Let me ask Dave Runke if he agrees with that. I suspect that Dave has a different view. Dave, likely to be a plea bargain to resolve this case?
I think there will be a plea bargain in the case. For one thing, if you look at this case dispassionately, if you look at it objectively from a lawyer's perspective, there isn't a death penalty in this case. I don't care how many victims come in. You got a guy who is mentally ill. You got a guy whose brother turned him in, solved the case when the FBI couldn't do it.
Dave,
the only thing he wants is no death verdict.
Dave, do you still take that position even if, because of Mr. Kaczynski's unwillingness to be examined, the judge keeps mental issues out of the case? Do you still think his mental problems will affect the verdict and keep the government from getting death?
I think mental issues are part of the fabric of this case. They're part of the atmosphere that the jury's going to breathe in this case. This is a guy who's gone off the deep end. You don't have to have an MD behind your name to recognize that.
Peter, one of the issues that struck me from the beginning as kind of one of the underlying issues in this case is the role of the brother. I mean, we don't know exactly what was said, but clearly he came away from meetings with the government thinking that if he turned his brother in, his brother wouldn't be executed. Do you think that to the extent that jurors get a feel for that, that could affect whether, in fact, there's a verdict of death in this case?
It might, but it's not admissible. See, all of what David said is true.
That's why I carefully asked you whether if the jurors get wind of it, it's likely to be a factor.
I don't think it's going to come in.
And it could conceivably come in if there's a penalty phase.
At the penalty phase. But see, here's the problem. The government, the Justice Department, spoke with the brother before they ever took the position that they were seeking death with Mr. Kaczynski. And despite the brother's urgings, even today, the government has not backed off its position that it's seeking the death penalty in this case. Largely because I think more weight is being given to the victims, as well it should be.
But the brother's position is troublesome. It's hard to believe that he's made a lie out of whole cloth. The guy who turned his brother into the government, seems to me it's unlikely he'd be coming forward and making up out of whole cloth.
Oh, I don't think he is. I think it is true that he spoke with agents of the FBI who probably sought his assistance and said to him, we'll see what we can do for you, and we'll try to avoid putting your brother or exposing your brother to the death penalty. But the problem is the FBI does not make policy decisions for the Justice Department. That's made by the Attorney General and her advisors.
An interesting moral issue. And Professor Perlin, I know you're an expert on moral issues, but first I want to ask you about insanity.
Right.
First of all, the question of competence has come up, and we should start there.
Right.
What is the standard to determine whether a person is competent to stand trial?
I think the first thing is that the question of competence and the question of insanity are two entirely different legal questions. And I think that has to be said every time we talk about that. Competence goes at the moment of trial. Can the person stand trial? Does he know what's going on? Does he understand the nature of the proceedings? And can he rationally and reasonably assist his counsel in the trial of the case? And
is it as simple as Sandy King's statement that he has to know that he's in a courtroom and not a bathtub?
No, I don't really think it's that simple. I think those are certain objective facts that a person knows. He is a defendant. There's the prosecutor. There's the judge. There's the jury. That's all part of it. But I think that's also the first part, the first level of cognitive knowledge. Beyond that, I think it's a little bit more functional than that. He has to be able to help his lawyer put on the case. And I think that's really the question here. I expect...
Well, does the fact that he may be at odds with his lawyers mean that he's not competent, or does it have to be a question of his ability to cooperate?
It's much more the ability. The fact that he may disagree with his lawyers is something to think about in a whole lot of context, but that is not generally seen as an indicia of whether or not a criminal defendant is competent.
Well, if Sandy were standing here right now, then she'd want to know whether there's any chance in the real world that this guy Kaczynski is going to be found in the next 10 days not to be competent to stand trial based on what you know.
I would be shocked. I would be very surprised if he's found incompetent to stand trial. To be found competent to stand trial is a relatively low level of ability. You don't need that much. And the fact that
so it's close to the bathtub standard.
Well, no, it's not really close to it's more than the bathtub standard. You need to know what's happening, and you have to be able to have some sense of what's going on in the courtroom, which I think takes it away from the bathtub standard a bit.
Let me move to the next level, which is there is an issue of whether or not some mental defenses, it's been called, should be raised on his behalf. Right. Kaczynski says no, his lawyers want to do it. What is the mental defense they are seeking to raise on his behalf?
There's really two separate issues here, and there may turn out, after there's a conviction, to be a third. Number one is the issue of insanity. Is he, by reason of mental disease or defect, not responsible for what he did? And in the federal prosecution scheme, after the Insanity Defense Reform Act of '84, they returned to a really more restrictive form of what used to be called the McNaughton test, an 1843 test from England that says,
what does it basically say?
It says basically, do you know the difference from right from wrong? And that's the test. It's a cognitive test. It doesn't talk about affect. It doesn't talk about emotion. It doesn't talk about conforming.
Is there another mental issue that's being talked about,
yes,
or a source of contention between Kaczynski and his lawyer?
That's number one. Number two is the question of whether or not he has what's called diminished capacity, which means he might not have had what's called the specific intent to commit the highest level, the most grievous level of murder, what we used to call murder in the first degree. If he had diminished capacity, he couldn't be convicted of the highest level, and then would not be subject to the death penalty.
So it would spare his life, though he would still possibly be convicted of something else.
Right. And even if, by the way, if he were convicted of murder in the death degree at the sentencing hearing, there would also be an opportunity for mitigating evidence to be introduced.
All right, David Roelke, let me ask you a question. There obviously is tension, and has been, between Kaczynski and his lawyers over this question of diminished capacity. Does the lawyer have an obligation to violate the client's wishes if the lawyer thinks that there's a viable defense and that maybe the client's mental process might not enable the client to evaluate the situation?
It's the worst kind of dilemma for a lawyer
That's
to be in.
why we ask you about it.
Yeah, thank you. My view is that I think I have an ethical obligation to raise what I consider the best defense, no matter what the client wishes, especially when the client is mentally ill. Taking off from what Professor Perlin says, you can be competent and be seriously mentally ill at the same time sitting in a courtroom. It doesn't disqualify you from standing trial, and it doesn't mean you got a rational understanding of everything that's going around you.
Well, Dan, as you sit here, from what you've seen, do you have the sense that there is some mental illness involved with Mr. Kaczynski?
I think there's clearly a mental illness involved with Mr. Kaczynski. Whether he's a high-functioning paranoid schizophrenic, which is what the defense is putting forward, or not, I can't say.
Well, let me ask Peter Harvey. I'll come back to you. But Peter, how is that Dave's assessment of this man, that there is some disease here that is troublesome? How is that consistent with your articulation of the view that the people want to see him executed, if he in fact did the crimes?
Well, I think a great segment of the public doesn't care whether he's crazy. They think he's crazy just to mail a bomb and kill people, assuming that the allegations are true. I think that the public, by and large, wants a trial, they want a conviction, and they want to see him put to death. There's a segment of the public that probably would be satisfied.
Which segment of the public are you in?
I am in the segment that says that if the evidence is what it is, and I think this will really be basically a trial about the evidence rules. If everything comes in that has been reported in the press, the typewriter, the manifesto, fingerprints, other artifacts taken from his place.
Seemingly overwhelming evidence.
Overwhelming evidence, he's going to be convicted. The fight here will be whether...
Do you think he should be executed? If those
no,
facts
not if he is mentally incompetent. No, I don't think he should be.
Is it your sense that the public, and I'm taking the public to mean jurors sitting in a case, are likely to be concerned about the mental status of a defendant if they're convinced of his guilt on a basis of overwhelming evidence? Sure.
I mean, you can, again, the standard of an insanity defense is very, very difficult to meet, as Professor Perlin has pointed out. The real issue in this case, and I agree, is a penalty issue. Do we want this guy executed? I don't think the overwhelming majority of people want him executed. In fact, when people are told there's a life without parole option that really means life without parole, support for the death penalty withers significantly.
Now, Professor Perlin, you and I have talked in the past about the fact that the public has many misconceptions about mental defect and insanity and how they're used. Do you find that people are willing generally to take a realistic assessment of mental defect and apply it in a legal case?
The answer is it's happening a little bit more than it was even 2 months ago when you and I last talked about it, but it still happens rarely. We are bound by myths. We take this position that the insanity defense is grossly overused, that it's almost always successful, that it's a get-out-of-jail-free card for the person who pleads it. The reality is very different, as both Peter and David know. It's pled in less than 1% of the cases. It's successful in less than a quarter of those cases. In 90% of those, both sides agree. There's no dispute. There's no ballyhooed battle of the experts. And besides, a person who's found NGRI not guilty by reason of insanity goes to a maximum security facility generally for much longer than he would have gone to prison had he been convicted of the underlying crime.
In this case where we're talking about diminished capacity, which involves a little more subtle analysis, do you think it's likely, if there is the kind of overwhelming evidence that we seem to see, that it will be a significant factor in either the guilt phase or the penalty phase if the jury has to consider the death penalty?
It may. Of course, it depends on a couple of confounding variables. One, the fact that Kaczynski has said, I don't want any of this in. And then again, this raises dilemmas for the lawyers, as David has just suggested, because we have cases that say a defendant who is competent has a right to refuse the imposition of the insanity defense over his will. That's one of the reasons why Colin Ferguson, the guy who shot the people on the Long Island Railroad, fired Bill Kunstler and Ronald Kuby. They wanted to plead the insanity defense. He said, no, I didn't do it because I was insane. He said, I didn't do it.
Now, Professor, you've suggested that you think people are maybe more inclined to look seriously at this maybe even than 2 months ago. But Dave Runke, the statutes, the laws of the United States have really been going in the other direction in terms of when and under what circumstances we consider the death penalty. Is that true?
Sure, that's right. The statutes have been expanding dramatically in the federal government particularly. In the modern era, we had a first death penalty statute in 1988 dealing with large-scale drug trafficking. But in 1994, Congress created like 50 to 75 new offenses for which the death penalty could be imposed and revived death sentences on existing statutes. So it's getting broader and broader.
So the timing of this event has a lot to do with possible results. Peter?
Well, if you notice, the Clinton administration has been at the forefront of legislation to impose death more often in federal crimes. So it's a difficult political situation for the Department of Justice under this administration to take the position now that they aren't seeking death. Remember,
well, since we started with the discussion of the plea in this case, do you think the fact that the Clinton administration as a whole has been so aggressively in favor of the death penalty makes it harder for that office to consider, in this case, a possible plea with Mr. Kaczynski?
No question about it. And remember, this is one of several cases. After Kaczynski gets finished out here in California, he has to come to New Jersey with respect to a killing. See, the difference here, you saw the reaction after Terry Nichols was, when the jury could not reach a verdict on the death sentence for Terry Nichols. People were outraged by it and felt he should have been put to death.
As we wind down, then, let me ask this question. Assuming that Mr. Kaczynski is not sentenced to death, do you think there would be similar public outrage in this case?
Yes.
Professor, do you share that view?
I do. I see it as different than McNichols because Kaczynski, to such an extent, comes close to our portrait of a, quote, crazy person. All the things, the way he looks, the way he acts, the cabin, the typewriter, all of that, that so much more closely sort of matches up in our own sense of someone who is, quote, insane, end quote. Much more than a guy like me. He would get more, I wouldn't say sympathy, but maybe a little bit more understanding.
Let me see if Dave Runke shares the view. Dave, do you think there would be public outrage if Kaczynski winds up being sentenced to something less than death?
No, I don't think so at all, because I think people understand the whole atmosphere of this case surrounds mental illness. I mean, you have the same Department of Justice plea bargains with Sammy the Bull Gravano, who committed 19 murders. He gets 6 years, and the Department of Justice thinks that's just keen.
Peter, if you were the U.S. attorney in this case, would you be looking for a plea bargain or now or not?
Yeah, I would have earlier. I would have made the deal for life imprisonment with no parole, particularly if I believed this guy were insane.
Well, we'll have time to see whether that turns out to be true, because that's it for this edition of Due Process. But we'll be back next week with a new legal strategy for dealing with drugs. Drug courts instead of jail. It's next on Due Process. Till then, for Due Process, I'm Raymond Brown.
Given the fact fact that the court has allowed in the diary and all the papers that he wrote, which I think make it really indisputable that he sent the bombs. And given the fact that I doubt he has a political agenda that's going to be attractive to anybody that's going to be sitting on the jury, it really is going to be a debacle. Whether he's going to try to use it as a platform for spouting off his beliefs, whether he's just going to sit there and allow himself to be convicted without fighting back, I mean, anybody's guess. And I think in some ways, he threatens to make a mockery out of the trial. Oddly, he might help himself with the penalty phase, because he could create such an impression of being bizarre that although he might not escape punishment, he might escape capital punishment.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.